Good afternoon, everyone, and all present in the session. I, Dr. Uzma, Assistant Professor, Faculty of Law, Integral University, welcomes you all in today's session of the Faculty Development Program. The Faculty of Law, Integral University, Lucknow, in association of Indian universities under the aegis of the Human Resource Development Center, in conducting 1 month faculty development program on the theme integration of intellectual property rights principle into teaching, research, and professional activities. Today we have third session of the module 4 of the FDP, and the topic of today's session is conflicts of interest in academic and commercial research. And to deal with this topic, we have our today's resource person, Dr. Muhammad Nizam Ashraf Khan. Sir, welcome, sir. Dr. Muhammad Nizam Ashraf Khan, sir, is currently working as an associate professor of law and head of IPR cell in GD Goenka University, Gurugram, Haryana. Dr. Khan has done graduation, that is BA LLB honors from Lucknow University, and post graduation, that is LLM with business law as area of specialization from Hidayatullah National Law University, Raipur. Dr. Khan has done a doctorate, that is PhD on taxation law from School of Law, Galgotias University, Greater Noida. Dr. Khan sir has a rich experience of more than 1 decade in teaching and academic administration, during which he was also associated with the School of Law, Galgotia University, Greater Noida, and Institute of Law, Nirma University, Ahmedabad. Dr. Khan sir has delivered lecture as resource person in various 1 week faculty development program on IPR, research methodology and research publication and ethics organized by E&ICT Academy, IIT Guwahati. Dr. Khan sir has established the Center for IPR Studies in School of Law, Galgotias University, and has been the coordinator for the same. Today, we are fortunate to have him, who has made significant contribution in the academic field. Therefore, without further ado, I would like to invite Dr. Muhammad Nizam Ashraf Khan sir to take the stage, where he will enlighten us on the on the topic of conflicts of interest in academic and commercial research. Stage is yours, sir.
Thank you. Thank you so much, Dr. Uzma, for this introductions. Am I audible properly? Is there any connectivity issue, or
Yes,
you are able
audible.
to listen me properly?
No, sir. Yes,
Okay,
sir.
okay.
You are audible,
All right.
and we are listening you very properly.
So this session is going live, right?
Yes, sir.
So the participants means we are not able to see what all of the participants are. So I just want to have a brief idea with respect to the background of the participants, whether all the participants are the faculties from law background, or is there any faculties from other background, other stream, or other area also?
Yes, sir. There is few faculties are other than the law background.
Okay, okay, perfect, fine, no issue. So, good afternoon once again to all my dear participants. So, I welcome you all on this very nicely, what you can say, the FDP on very nice topic with respect to IPR. So, till now we have seen a lot of FDPs and awareness program with respect to intellectual property right, but this is with respect to the integration of IPR into teaching and academics as well as the professional activities, because you must have studied or you must have heard a lot about IPR during this particular FDP. Just let me start the slideshow of my FDP, this PPT. Is it now visible in slideshow?
Yes, sir. presentation is
All,
visible.
all right. So this intellectual property right that you must be having the knowledge. I hope that you are having the knowledge with respect to intellectual property, what all the aspects and what all the areas are dealing with respect to intellectual property. So, like with respect to one of the important aspects of the intellectual property is patent, which is dealing lot of fields, whether it is technical field, whether it is pharmaceutical field, whether it is mechanical field. So lot of inventions are required. So from that point of view, this particular, not with respect to patent, we can also see the research in the in the form of copyright. There are a lot of copyright issues which may occur, authorship issues or the ownership issues with respect to copyright, which may arise in the field of that particular intellectual property right. So from that point of view, this topic with respect to conflict of interest in academic and commercial research is very important, right? So like what we have said, that with respect to the academic research is fine. There are, if we talk about with respect to the copyright, so there are two concepts with respect to the copyright. One is the plagiarism and the other one is that of infringement, right? You can say the piracy or the infringement. So if I ask that what is the difference between the infringement and plagiarism, right? So this is the thing which you can say is related with respect to the academic environment, academic field. As soon as you are just crossing that particular academic line with respect to the commercializations, there all these piracy and infringement things come into effect. So you can consider, or I can give you this very example with respect to the difference between uh, this copyright and plagiarism. So, like, what is with respect to plagiarism? If we talk about the legal status with respect to plagiarism, so this is not at all having any legal stance till now with respect to plagiarism. Plagiarism is being considered as an ethical practice, right? Ethical practice means like this is ethically degraded, or what you can say that this particular plagiarism is being considered as that it is immoral, it is not allowed in the academic environment. If there is any kind of plagiarism which is being done in any academic research or any research, then there is not going to have that much of the punishment or the consequences which we can have or we can see in the case of infringement. In the case of infringement, what is happening is, suppose if there is an infringement of a copyright, then the punishment is in the form of imprisonment as well as the fine. But if we talk about with respect to the plagiarism, so what is that particular punishment with respect to plagiarism? Only that kind of, like, the particular academic research will not be considered, or that particular job may be, that particular researchers may be expelled or can be rusticated with respect to their thesis if it is related with research, or if it is related with like academicians, then that particular academicians will not be having any promotion. Such kind of punishment is there, right? So from that point of view, you can see the difference between with respect to the academic things and commercial things. Commercializing a particular research is having the great, what we can say, monetary potentials. So that is why from that very point I would like to take this very topic where it is being said that the conflict of interest in the academic and commercial research. So these are the two things. Means one way, there is a particular academic research where the conflict of interest may arise. There may be the other field where the commercial research is being done, and there also the conflict of interest may arise. We always have to keep this point in mind, that is with respect to the particular intellectual property right. So whatever academic research, whatever commercial research we will be discussing here will be mainly focused on intellectual property right. There may be the other type of conflict of interest, but we are not going to discuss, we are not going to deal all those things. And just try to this thing, just try to remember this thing in your mind, that this conflict of interest whatsoever is the finest and the greatest research is being done. By the conflict of interest, the result may have been hampered. The result or the outcome can be manipulated, so it can create a lot of dilemma with respect to the integrity or the quality of that particular research. So we should be very clear what is that conflict of interest and how we can avoid that conflict of interest. So this is the point from where I would like to start. So during this session, we will be discussing what is the first, you need to understand the objective of this very topic, why we are studying this conflict of interest. So first, the objective, the first and the foremost objective with respect to this very topic is that you will understand what is the conflict of interest in the research, right? What is all about this conflict of interest? We have heard, or you may be, or you must be having the knowledge with respect to conflict of interest, but what all the examples may be with respect to that particular conflict of research, conflict of interest in academic and commercial research, that we will be able, that we will be discussing, and I hope you will be clear with respect to the concept of this conflict of research in interest, sorry, in research, conflict of interest in research. And we would also be exploring how this conflict of interest affects academic and commercial research. And we would be also discussing that the strategies, means one of the objective is that you will be able to know that particular strategies, how to manage this conflict of interest in IPR related research, be it copyright, be it patent, be it geographical indication, whatsoever is that particular kind of research where the conflict of interest may arise. So what may be the strategies to manage those conflict of interest, that we will be discussing today, and that is also one of the objective. And what are all the agendas, mean the points that with respect to this session, that we will be discussing the definitions, that is very simple with respect to the types of conflict of interest, what are the various types of the conflict of interest, like personal, financial, all other professionals, that we will be discussing the conflict of interest in academic research, what conflict of interest may arise in academic research, also what conflict of interest in the commercial research may arise, what kind of or types of conflict of interest, that we will also be discussing. Then how we will be managing this conflict of interest, what are the best practices, what are the guidelines, like there are a lot of guidelines with respect to this conflict of interest, that we will be discussing. And then finally we will be also discussing the certain case laws, the live some cases where this conflict of interest issue has been arises, be it the case of GSK pharmaceutical company, that is Galaxo Smith Kline pharmaceutical company, or any Monsanto, that is agricultural pharmaceutical companies. So you can see that the most of the cases where this conflict of interest related to IPR is coming or has been arisen, that is on the basis of this pharmaceutical industries, right? So whether you are aware or not, you are knowing that there is a treaty or the conventions related to IPR which is being considered as very influential or very powerful, that is TRIPS agreement, right? TRIPS agreement, trade related aspects of intellectual property rights. But you would be surprised to know that the particular TRIPS agreement, which was being drafted during that particular time, 1994 and 1995, when this came into effect, right? And before that TRIPS agreement, we would be having like Paris Convention with respect to dealing the international intellectual property rights. We were having one convention, another convention, which was for separate aspects of intellectual property. Not all the IPR things were being covered or were being governed under one kind of treaty or conventions. That is why TRIP has come into effect. But the surprising fact with respect to this TRIPS is that there was a huge lobby which was being done by that pharmaceutical companies of the US. All the US pharmaceutical companies, they have lobbied behind the drafting of the TRIPS agreement. So what does it mean? Means they have drafted the particular terms in their favor. Like you have seen that India was being considered as one of the robust country with respect to generic medicines from 1970 till 2005, and it was in 2005 when this particular patent products with respect to pharmaceutical things was being allowed, right? So with respect to during these 35 years, they were not able to cope up in this Indian market. And now you have seen the lot of issues are coming into picture with respect to pharmaceutical things. So there this question may come with respect to the this conflict of interest. There these questions may arise. What are all the case these discussions are there that we will be discussing. So you can understand that most of the IPR cases related to the pharmaceutical companies is that these for big pharma companies, they are just taking that of the patents which is at all in a public interest, not been allowed. So many time it has been said, while is it Doha Declaration, which was being done in 2002 in Doha, where it has been said that in rare disease, the compulsory licensing with respect to the medicine can be invoked, right? Can be invoked or can be claimed with respect to that, right? Or you can see that of the Bear versus Natco case, where the compulsory licensing was being invoked in India for the only one time in India that has the compulsory licensing has been invoked with respect to these pharmaceutical companies. So these pharmaceutical companies, they are the very big, powerful peoples. They know, and they what you can say that they just divert or they just convert all these laws into their favor. So from that point of view, you can understand the conflict of interest, what that can be arisen with respect to this academic or any commercial research which is being dealing with respect to that pharmaceutical companies. I can give you one example that I told you just now with GSK Pharmaceutical Company. Galaxo Smith Kline Pharmaceutical Company. There was a drug dispute with respect to this very company. During this 2000 means around 1990s and 2000 and 2010, uh, this GSK Galaxo Smith Pharmaceutical Kline, this Galaxo Smith Kline Pharmaceutical Company, they this is one of the largest pharmaceutical company in the world. They have been fined $3 million. They have been fined $3 million for the what you can say for the manipulation or manipulation of a particular research by which a drug painkiller they have just promoted. They have just promoted a painkiller where the kind of potential clinical research was not being done. So you can understand the scientists who were involved in that research, they have received a huge money, millions of dollar they have received from the company, and they have given the what you can say that they have given the outcome or the research in the favor of that very company. And this was found out, and this was being challenged in the US court, and where this particular pharmaceutical this GSK company, they have compromised to pay $3 billion. So you can understand how the research integrity and other things that they can manipulate from those very point. Or we take any example with respect to this academic research. Suppose there is a particular potential what can you say that good researcher, academic researcher is there, is doing a particular research and is finding a potential novelty or the discovery with respect to their a particular technology. Now knowing the potential of that technology, what can be the situations that that very person can approach to any startup company, which can be like financed by some of the industrialists, or the venture this capitalist. So now the question you can consider, what may be the result with respect to a particular research which is having the financial support from the side of the capitalist, right? The result may be hampered, the result may be such which may in the favor of those venture capitalist or industrialists. So such type of conflict of interest may have arisen with respect to all these things. Now, starting with respect to this conflict of interest in academic research as well as in commercial research, the first thing which comes in our mind, or which you may ask, that is, what is conflict of interest, right? So, so what we will be doing during this particular presentation or during this particular lecture is that first I'll be delivering. So during the lecture, if you have any doubt or if you have any questions, right? So you can either, if it chat box is available for you, you can write or you can give your questions to the moderator. Means we will be taking all your question at the end of the lecture, after the completion of this lecture. So if you have at any points have any question, you can note it down your questions, and then when the question answer round forum will be open for you for the discussion, then we will be taking all your questions. Fine. So now coming to this conflict of interest. So usually you are very clear with respect to the conflict of interest. So basically it is a particular, what you can say, it is the kind of a situations where the an individual's or a person's personal or any financial interest that is being compromised, or that appear to be compromise their judgment or the integrity in research. Whatever will be the outcome of a result, whatever will be the result of a particular research, that if it is being compromised on the basis of any kind of interest, any conflict of interest, then that is been the point where we can say that the conflict of interest has arisen, right? So the example, for example, if I am doing a research in a particular institution. Suppose I am working is in GD Goenka University, and in GD Goenka University, I have been given what you can say that I am the reviewer of a particular research paper. Just consider like this. Suppose I am the reviewer of a particular research paper, and when I get to know that the paper which I got for the review is one of my known or is one of my acquaintance research paper. So now I would, what is my duty? I should have to be immediately tell this, that no, this my personal interest may come in these situations. I may be the biased while doing the review of this particular research paper. So I would like to recuse myself from this very review of this research paper. But if I am hiding this fact that the research paper for which I have to review is of my known or is of my acquaintance, then in that situations there this conflict of interest will arise, right? So there are different types of conflict of interest. We will be discussing all these things, like the personal conflict of interest, professional conflict of interest. So what may be the personal interest, like of any promotions or any kind of family support, or any societal support, if it is being given with respect to that particular researcher, then that is being considered as personal interest, right? Personal interest means, like for example, if a particular research is being done, and in that particular research whatever outcome is coming, I am not disclosing that particular negative points of of that research, because if I will be disclosing the negative points of that particular research, then my promotion may get hampered, then I did not may get promotion. So if I am just hiding the negative points of a particular research which has come after doing the research, just for my just as the hindrance in my promotion, then that is being considered as my personal interest. So what is that of professional interest? Professional interest comes where that particular duty with respect to institute is being arising. So in that situation, what may happen? Suppose if I am doing a particular research, and in that particular research, I want to commercialize, I have come with a particular invention, and I think that this invention can be commercialized in the market, and I start a startup, and where this particular institute is also coming into picture, university is coming into picture, and university is saying that because you were employed when you did this invention, so I should also be the joint owner of that particular invention. So in that situations, the professional interest will come into effect. That how means my duty with respect to professional interest was that the university, I am employed in university, and university is working with respect to promotion and research and all these things. Now it is not being considered I am taking care with respect to my startup. There this professional interest may arise in, right? So this is with respect to personal versus professional interest. The financial and non-financial conflicts, you are very clear. Financial means whatever the monetary benefits, whatever kind of financial benefits one is getting with respect to a particular research, that is being considered as financial conflict or financial benefits. For example, if I am doing a particular research, and in that research the funding is being done by a particular company for which I am doing that, the what you can say that the criticism about that very company. If I am doing the criticism, or if I am seeing the negative points of a particular company, but the funding or the sponsorship is being given by that very company, then what may happen? There may be the chances that I will not be able to do proper research, because that the particular company has sponsored my research. So in that situation, the financial things may come into effect. So such kind of financial conflict may arise, that I am doing a research of a company which is in itself is the financial supporter or in my research. So in that situation, the financial non-financial conflicts, what is that non-financial conflicts? So non-financial conflict, you can try to understand with respect to that the family or any relative promotion or any relative's interest if involved, that is being considered as non-financial. For example, if I am for example, if a professor is sitting in an interview board, in a selection board of a panel, where his or her spouse is one of the candidate, right? So what may be the chances? He or she would definitely like to select that particular his or her spouse in those situations. So that is one of the conflict of interest which is being considered as non-financial conflict of interest. Academic integrity at risks, that we have already said that if there will be any kind, at any time there will be question with respect to this particular conflict of interest in research evolves or is being discussed, then ultimately the academic integrity would be hampered, and what is the point that it is going to be at risk, right? So academic integrity definitely at all is going to be hampered. Now, these are like the types of conflict of interest that I have told you. Personal conflict of interest, that a researcher's personal relationship with the family, friends, that influence their work. If one of my known is there in the panel, is there in that particular selection, and I am the one of the panel to select, or I am taking the interview. So this is like the personal interest in, right? So you have heard about this kind of situations where any family member is there, and in many of the cases, if you have heard, if you have seen, whether it is before the High Court or before the Supreme Court of India, many of the judges is recusing themselves from a particular case, right? And why they are saying that? Because earlier, because that case may have gone to that Supreme Court in the appeal case, and that case may have in their subordinate court in High Court, and during that time the judge who is sitting in Supreme Court, where the matter has been listed in a particular court's in a particular judge's court, was one of the counsel in that very case, right? Suppose a case is coming before the Supreme Court judge, and that particular Supreme Court judge was earlier the counsel in the lower, maybe the High Court, or in other cases. So in that situations, that particular judge recuse themselves by saying that conflict of interest may arise, because he or she has uh, fought, or he or she has taken that very case with respect to that the counsel or the advocate with respect to favoring that party. Now he or she has become the judge, he or she has to see, so there may be the conflict of interest may arise. So with respect to that, it has been said that these situations may arise, and this may can be considered as the conflict of interest. Financial conflict of interest, what we have said, that the funding from commercial entities that is impacting the objectivity, right? If I have to do a environment impact assessment of a factory, and the factory itself is financing my this empirical research, then what may be the outcome? The outcome may not be that of honest and true, because that particular entity, that particular factory would not like to know that what is the actual situations with respect to that very research of environment impact assessment, right? So professional conflict of interest, that we have seen that the multiple roles or the professional activities which is ultimately affecting any kind of judgments or any kind of decisions, so that is considered as the professional conflict of interest. Intellectual conflict of interest, which is also one of the kind of interest where we can say that the non financial or the other way in kind, the particular conflict is there. Fine. How it is happening? Intellectual conflict of interest, like the influence over the research output due to prior commitment or intellectual biases, right? So that I gave you the example with respect to the Monsanto. Monsanto is one of the agricultural pharmaceutical company, right? And this was being alleged, and this was being allegation was being imposed upon this very company, that this company has contacted the particular researcher with respect to providing the result of GMO, genetically motivated organisms, for the giving the results in their favor. They have contacted to their particular researchers, right? So in that situations, whatever will be the inventions, whatever will be the result, that is being compromised by the company between that particular company and the researcher. So there this intellectual conflict of interest may arise, or the situations that I gave you, or the example that I told you with respect to a particular research in the institute, right? Like I am working in the institute, and in that particular institute the IPR policy is there, and if IPR, according to IPR policy, it is been said that if that particular invention will be done, then the first honor will be that particular university, because that of the resources and all the platforms is being provided by the university. That is why if any research is being done by the researcher, or the student or the faculty or any kind of professor of a university, then that will be the property, intellectual property of the university. This policy is now removing the conflict of interest between the researcher and the university. But the situations you can see with respect to what may be the intellectual conflict of interest, that you are doing a research, and in that particular research you have got that much of potential that your research is being converted into a patent or invention, and that invention is now you want to commercialize it, you want to give the license to any third company, and where this particular university may also come into picture and can say that I am also one of the owner or the co-owner in that particular invention which was being done by you. And the reason is that you have used our platform, you have done this research while you were employed in our or this university. So this is the example with respect to intellectual conflict of interest, right? So these are the various types of conflict of interest where this situation may have arise. If one of the famous case of this Dolo 650 medicine, this Dolo fever relief medicine, just 1 or 2 year earlier, this case was being filed with respect to that Dolo 650. What had happened in that case, Dolo 650? The allegation was that the particular pharmaceutical company has given the freebies to the doctors for prescribing this medicine, and this was being done during this COVID time. That during COVID time, the people who were suffering from fever, the doctor were prescribing this very medicine, Dolo 650. Right? It is a pharmaceutical company based in Bangalore, Micro Labs Limited, names that is names the company, and the company has given approx 1000 crore benefits to the doctors in the kind of freebies, not in cash, in kind, right? And on the basis of that, the doctor has recommended those medicines, prescribed those medicines. So there, this question with respect to conflict of interest may come. There, the question of with respect to conflict of interest come into picture. And this was the point where we can say that this was the PIL. A PIL was being filed in the Supreme Court by one of the NGOs, where they have said that this much was the compromise, the serious issue, and the Supreme Court has also taken a note of this and said that yes, this is a serious issue. If this has been done with respect to the conflict of interest, then this serious consequences may have happened, right? So you have seen that what is the result and what was the decision with respect to that. But now if we see, we have to see the conflict of interest, then you can understand such type of conflict of interest can come into effect. Now, what type of conflict of interest may have come in the academic research, and how this is happening with respect to this conflict of interest in academic research? So, you can see that the conflict of interest risks, which may include that the favoring certain research outcomes from personal gain, right? You give the result in our favor, and within the result of that, we will be taking care of your personal issues, we will be taking care of your personal gain, we will be giving you one kind of things like this XYZ amount, a bungalow, a car, and XYZ, right? So if a particular researcher is doing the research, and in that particular research the outcome of the research is being manipulated, the integrity and the transparency has been manipulated for the personal gain or for any kind of benefits, that is being considered as the conflict of interest in the academic research, right? Like any kind of consultancy is there, and with respect to the consultancy, that involvement in that particular private consultancy while conducting the research, If a research is being done and in that particular research a private consultancy is being also used. Private consultancy means like that of the personal opinion with respect to that kind of relevant research is there. So in that situations, there are chances that the conflict of interest in academic research may involve. So the examples that I can give you this potential academic conflict of interest, what may be the one of the major or the most prevalent nowadays is this ghost authorship, right? This is also applicable in case of the plagiarism, that the ghost plagiarism, that is also one of the kinds of the plagiarism. So ghost authorship, what happens in ghost authorship means that particular author is the ghost. Ghost means not traceable. Nobody knows that who is the author of that particular research or a particular piece of what you can say the research paper or a work, right? So that is being considered as forced authorship. And in recently we have seen in this Monsanto case, the Monsanto company case, the counsel for this Monsanto case before one of the case reached before the Supreme Court, and this Praveen Anand, who is the managing partner of this Anand and Anand, one of the IP firms in India, was was uh, uh, was fighting this Monsanto case, right? And the Monsanto has been like the allegation was being imposed on Monsanto, that Monsanto has used some ghost authorship for providing a kind of research, because that Monsanto company is related with that agricultural pharmaceutical company, and they are doing a lot of research with respect to the academic research of their agricultural products. So there they have used, means this allegation has been used on those particular on that particular company, that the host authorship has been used by that very company. So, what is that ghost authorship? I think you are clear that wherever the author of a particular research is not known or is aware, somebody for some, what you can say, for some financial charges or professional fees, taking a charge or the fees, and in result of that, doing a research, that is being considered as ghost author, right? Means someone is doing a research and taking certain financial monetary benefits or some financial charges and giving it to you, and you are claiming that particular research as yours. You are claiming yourself as the author of that particular research, but actually you are not the author of that particular research. The author of the research is some other person who has done this research on the pretext of some financial benefit, some monetary things, right? So there this question comes with there this point comes with respect to ghost authorship, right? Unclear authorship responsibilities, this may also that the authorship responsibility is not clear, that who all will be doing what. I have to do a particular research, or if there is a joint research is being done and one of the author is dormant is not doing anything, in that situations what may happen, that at the end when the result is being done, then he or she may come and can say that no, I have done this research, ultimately is not being done. Then there the question with respect to the authorship responsibilities also come into effect, right? So there, if there is any kind of unclear authorship responsibilities, then also this conflict of interest in academic research may arise. This personal financial stakes in academic outcomes, so that we have said that if the outcome of that particular research, the result is being compromised, like any negative point, which is the outcome or the result of a particular research is being is been what you can say not disclosed or hidden, then with respect to that particular financial growth or financial health, and that may be considered as the conflict of interest. So, with respect to the conflict of interest in academic research, we can see that if we are doing a particular research where the certain financial benefit is being involved, and because of that any personal growth, any personal interest is involved, and because of that the ultimate outcome of the result is being hampered or is not honestly displayed, disclosed, then that is being considered as the conflict of interest in academic research. That is the clear cut case of conflict of interest in that academic research. Now, what may be the conflict of interest in the commercial research? Like commercial, we have seen that what is happening with respect to commercializations. So, the one of the most opt example is with respect to these pharmaceutical companies, right? So commercial pressures is being given that give the result in our favor, or you have to give the result in so and so date on in so and so situations. So that is being considered as commercial research. So basically the pressure that often result in the terms of conflict of interest. The conflict of interest is being arisen where the commercial pressure is being given such by those kind of big giants like pharmaceutical company, this nanotechnology company, or this biotechnologies companies. They are giving that particular pressure and saying that no, you are not required to give the result in that favor, you have to give the result in so and so manner. That is the conflict of interest in commercial research. Fine. Means if you are doing a research which involves the commercial or what the companies or the industries directly, and the particular result is being compromised, then that is being considered as commercial risk. The simple thing. So you may ask this question: what is the difference between academic research and commercial research? Academic research, which purely involving or doing a research with respect to academics. Commercial research means if you are doing a research with respect to the working of a particular situation. So for example, that the latest case nowadays is with respect to ENY, that Ernest and Young company, one of the employees Indian who has been died or who has been suicide with respect to the work pressure in that particular Ernest and Young EY company. So in that situation, suppose now you are having this particular idea that you want to do a research where you want to see the MNCs or the this corporate sectors working conditions of the women or the working pressures, such kind of research you want to do of those of the MNCs in maybe in this IT field, maybe in this like that tech field. So such kind of situation, consultancy companies, consulting companies, if you want to do the research in that, and if that particular research of your research is being pressurized by one of the giant company, maybe Google or Microsoft or EY is pressurizing to that particular researcher that no, you don't have to give the result which may be against our company, where it is being shown that we are giving the duty of our employees for doing the work up to 14, 16, 15 hours, not getting that much of the time for themselves. Then in that situations this will be considered as clear cut, this will be considered as the commercial research, and conflict of interest will arise if certain kind of risk, certain kind of benefit or interest is being given to that of the researcher, right? So what are the key concerns that are with respect to commercial research? The biased results will be uh, can be provided due to this corporate sponsorship that we have said, right? You are doing the research and in a particular research, a company is giving you the sponsorship, and that the research that you are doing is also involving the working of that very company, or the company is working on that very field, and you are doing that, the environment or the pollutions, that who is that of the aggregator, pollutant aggregator, such kind of research you are doing, that what are all those stakeholders who are the pollution aggregators. Now, one of the company who is being considered as the biggest pollution, that particular biggest pollution aggregator in that situations, and that very company is also sponsoring your research, so there may be the chances with respect to the biasness or the biased result will be coming in that situation. Fine. So IP ownership is also impacting that research choices. Like the people are saying that will the particular ownership, be it the copyright, be it that particular patent or any other intellectual property, the ownership will be also with respect to that of the researcher, not of the company, but you have to give the result in that situations. So that may be the situations where the conflict of interest in commercial research may have arisen. For example, you have seen that the research funded by a company with vested interest in specific outcomes, right? Or the one more example, that pressure to file the patents early, that is affecting scientific integrity. Right? Me means the pressurized, that the particular the researcher is being pressurized that to file the patents early, because in patent there is a situations of early patents also, and complete specification within 12 months of the complete inventions, a patent can be filed, because they are also apprehensive whether the same invention can be done by others. So if some other persons can claim that kind of that particular research, then their research will be going in vain. So in that situations, the objective behind that, the what you can say, that the partial filing of the patent was there. But if such kind of pressure is being given to the researcher with respect to filing the patents early, and also affecting the scientific integrity, then that is the clear cut case with respect to the conflict of interest in commercial research. So wherever any kind of this financial benefits are involved by those particular big giants, pharma company, or any kind of industries or companies, there are very high chances that the conflict of interest may have arisen. Now, going forward, we can say that what may be the impact of the conflict of interest on research. So, I think you are clear till this point that what may be the impact of this conflict of interest in any kind of research, right? Like the first impact will be with respect to the integrity of the research. The integrity of the research at very point, at any point, wherever it is been, what you can say, the fact is being disclosed that this particular thing was having certain interest or the conflict of interest, the ultimate integrity will be questions or compromise. So the research integrity would be compromised with respect to the impact of conflict of interest. The conflict of interest means is having the major or the first and the foremost, the what you can say, the effect that affects directly with respect to the integrity of the research. If there is any, at any point we can say that this, so this is being said that research if research is being considered philosophically, it is being said, a philosophical statement is being said, that if research is being considered as a balloon, then conflict of interest is considered as a needle which can be pierced in balloon to burst that, right? If in any research you are just praising this very point that there was certain kind of conflict of interest, the ultimate integrity of the research will be questioned, will be compromised. This is the major impact of that particular conflict of interest in research. They are compromising that integrity, which is destructing that ultimate result. And the public perceptions would also be that the credibility, the questions of the credibility with respect to the institutions which were being involved in that research, or the researcher who were being involved in that particular research, this will be directly affecting, right? So like it is being said that if any public figure person is there, and that public figure person is like of you can take the example of judges, right? Not with respect to research. If the judges, they have to deliver a judgment against a particular company where they are holding that kind of, what you can say, the shares in that very company, so we can say that the particular judgment may not come in against that very company because there is a wasted conflict of interest of that judge, right? Be it not in the court or in any manner, if you are supposed to have to get delivery to that situations, or you have to do the research of a particular working condition of a company, and that company, in that company you are having that of that particular shares, or the company is saying that you give the result in our favor, we will be giving this much of shares in our company, right? So in that situation also, this will be considered as that the ultimate, the research will be hampered, and this particular conflict of, because of this conflict of interest, right? The policy making or public trust, that would also be influenced. So what are the consequences with respect to this IPR? That the IP disputes may come, the ownership with respect to financial interest, hidden financial interest is there with respect to the IP inventions, and now the question with respect to the ownership may arise. The dispute may come with respect to that, right? So this may be the consequences if the conflict of interest in any research involves, then that the situations may be that the IP ownership disputes may have arisen because this was not being disclosed, that whosoever is being doing the research, whether it will be the researcher or that particular company or that particular institute, will be having the ownership with respect to that IP. Fine. So this is like the impact, direct impact that you can consider is being given. Now moving forward is with respect to IPR and conflict of interest in academic research. Now we'll be connecting with the IPR. What is the role of the IPR in respect to the academic research? So we have said that academic institutions, they often claim IP rights for the research findings, for their what you can say, this accreditations, NAC, NBA, NIRF, and all these, for this ranking to show that their institute is a good, that particular research is just considering or putting the research at a very high place and rewarding the research. So with respect to that, the particular inventions that the particular invention which is being done by the employees, either the student or the researcher or the academicians, the particular claim of the IP right is with that particular institutions or the university. Fine. So academic institutions, they always nowadays claim, in every institute, in every university, you will be finding an IPR policy where it is being clearly mentioned that whatsoever the invention, the IPR will be created or will be generated during that particular office hour or during the course of employment by any employee, by any researcher, that will be the property of the university, and this is with respect to their research rankings and the fundings. Fine. And this the conflict of interest, this is arises when the researcher's ownership stakes are not transparent. Clear? Like you have seen that the government of India in 2016, they have also come with this IPR policy. You have seen that the now we are having an IPR policy, but the actual IPR policy which was required to be framed, but there was some, what you can say, certain development was being done when this in 2014 this government came, this particular current government came, and they said that this IPR thing is taking lot of time, so they want to just increase the, see that what are all the hurdles and the problems with respect to that, all these intellectual property laws. Copyright is there, patent is there, geographical indication is there, trips and was or has also been come, and that has been effectively implemented in 2000 till 2005 and 10. Now even after that, whatever, take the example of the patent India, if we are doing the, if we are filing a patent, then it was usually taking 5 to 6 years for the grant of the patent. If any of the inventor is filing a patent in India, that was taking hard, that was taking minimum 5 to 6 years, usually four, minimum 3 to 4 years. So the government thought that there should be a policy, just see that what are the hurdles and the problems with respect to that. Then the committee was being drafted in 2014, and Professor Shamnath Basir, along with the other, this giant, or the, what you can say, the big IP academicians and the professionals, they were part of that very committee. But and the committee has presented their report to this particular Ministry of Commerce and Industry, the relevant ministry. But that report was not being accepted by the ministry, and that particular the committee was being changed, means that the people, the members of the committee was being shuffled. And then this particular new committee came, and that committee has again worked on that, and they have finally presented their report in the form of IPR, national IPR policy in 2016. At that time, the then finance minister Arun Jaitley was there, and he himself has introduced this policy and said in 2016 that we have now in that IPR policy. Now, in that IPR policy, that at that time the awareness was very less, so that the awareness about the intellectual property was required. So many times has been said. Now, what I want to say here is that why I am discussing this IPR policy, because in that IPR policy, the government has said that 50-50 ratio has been given, right? Means that particular ownership, if any academic institution is involving a particular research, or is involving any particular patent or any intellectual property, then the 50% will be given to that particular academicians or the researcher, and 50% will be going to the institute or university, right? This 50-50% is there. This is as per the government policy, that 50% ownership will be with that particular institute, 50% ownership with that particular researcher or academician, irrespective of the fact that the research is being done in the university or the institute. Fine. So this is now been settled, this has been cleared. So we are saying that this conflict of interest may have arisen if the researcher's ownership stakes is not clear by the university or by that particular research, that what percentage that researcher would be having. Fine. The researcher would be getting that academic recognitions with respect to that, the patent is being filed, his patent has been published, patent has been granted, and university can show in their academic ranking also, institutes ranking also. But whenever this is going for the commercialization benefits, the commercial exploitations, any third company who is going to take the license of that intellectual property, and there this monetary benefit comes, then the monetary benefits will be divided between the university and the researcher, right? So there the monetary benefit ownership comes into effect, where it is being said if it is not transparent, then the conflict of interest may have arisen. That for example, that I have told you, that a professor which is holding shares in any startup company that may commercializing research developed in their lab, right? So a professor which is holding shares in a startup that is being like what we have said, that the commercializing research developed in their lab, then in that situations that conflict of interest may have arisen, or confusion over this patent rights between the institutions and individual research, the example that I have given to you, right? It is being considered as, it is being considered as that if you require, then that can be arisen. Fine. So this is with respect to IPR and the conflict of interest in academic research. Now, what all the conflict of interest may have arisen in that commercial research is also is there, right? So we can see that the IPR and conflict of interest in the commercial research, what can be. So what is the corporate influence? We have said that the companies, they usually, they often fund those research that could directly benefit their products. The example that I have given you, that this GlaxoSmithKline, or the example of Monsanto, that is agriculture pharmaceutical company, what they are doing, they have given a handsome amount to those particular researcher to give the result in their favor. Fine. So the company, they often provide, they often give the fund to certain kind of research where they are directly having the benefits about their, what is being said in that particular business model, in that particular management policy. If anything which is being given in business school or in business IIMs, this policy is there. They are usually this statement. The fact is saying that if anything is providing free of cost to certain people, so in that situation it is being considered as the people is the product, that the company is going to use them as product, and with respect to that they are giving certain things as freebies or free of cost. So the company knows with respect to all those interest that which research is directly giving the particular, what you can say, that the marketing growth, their this marketing go up or high with respect to those situations, that is being said. So in that situation the company can fund those research which is directly affecting their benefits. Or patent driven research, they may also push researchers to prioritize research results that favors IP claims over scientific progresses, right? So whatever is that kind of research which is being done with respect to patent, and that pharmaceutical, for example, any pharmaceutical company is there, either this Novartis is there, or any like of this Abbott is there, or like any GSK that I told you, this GlaxoSmithKline pharmaceutical company. If they are doing a particular research and they are prioritizing that the result may favor with respect to their scientific progress, then in that situations this will be the clear cut case with respect to conflict of interest in their commercial research, right? So the examples that the patent, the patent races leading to early disclosure of incomplete results, that they are concerned with respect to that of the results, that the results may be incomplete. In that situations, this conflict of interest with respect to the commercial research may be involved, or the commercial pressures to license those IP rights before full validations. That particular validation is not being done. Even after that, the particular licensing or IP right is being sold to certain person because of the pressure which was being given from the side of the commercial entities. That is the point where we can say that this conflict of interest in commercial research may arise. Fine. Now, this is all about with respect to the conflict of interest and IPR and the particular academic and commercial research. Now, the guidelines with respect to the managing conflict of interest. So, what practices we may use with respect to avoiding this conflict of interest, right? So, clear cut, clearly disclosures should be there. The best practices, one of the best practice with respect to avoiding or managing the conflict of interest is just disclosing all those potential conflicts, right? If there is any financial conflict, any personal conflict or any professional conflict, so this should be very clearly disclosed well in advance that this particular person, if is doing research, is having so and so interest in that very company or in that very institute, so the result may not be of that very point. So that is why this disclosure is being given. Fine. So better is that to give the complete disclosure about those potential conflicts before any research, that this research is not being done. For example, if you take the example, a particular research is being done by the SEBI, Security Exchange Board of India, and where it has been said that the particular agency of the SEBI is doing the research, then in that situation, that we can understand that what may happen. So what may be the situation if you are doing any research? So in the form of a disclaimer, you can give directly that this very research is not having any kind of potential conflict with any personal, financial, or professional conflict or interest with so and so person. That is why there is no question with respect to any integrity of the research with respect to the conflict of interest, right? Complete disclosure is being given. Independent oversight of those research outcomes, right? Whatever is the outcome that is being independently checked or independently seen is not directly affecting that. By that is also this conflict of interest may have been avoided. Clear separations between funding bodies and the research team. The funding is team or the funding agency is totally or is completely not in that particular, not having any connection with that research team. This is also one of the way by avoiding the conflict of interest. So if any institute is giving that kind of what we can say, any institute is giving that kind of funding where that research team is not involved in that situation, so by that it is clearly considered. Like we have seen that in commercial conflict, what is happening, that the particular company is giving the fund for which that research has been done. In that situations, this is not allowed, right? IPR specific guidelines. So that is also that I told you that is being given that the every institute is having the IP policy, and in that IPR policy that the ownership whatsoever would be having the ownership very clearly been mentioned. Like that is why the government of India has come with that particular 50-50 ratio monetary benefit with respect to the IP ownership is there in the case of university or academic institutions, right? So this is there should be very clear cut institutional policies on this IP ownership. And then disclosure requirement for research involved in both academic and commercial ventures, right? If there is any kind of ventureship with respect to that particular academics and those commercial ventures, so it should be very clearly disclosed for that particular researchers, right? And establishment of independent review board of research with IP concerns. So if there is any kind of research is being done, then there should be an independent review board with respect to the research. So establishing those independent review boards. So these are certain kind of what you can say that the practices that can be followed with respect to the conflict of interest. Now we'll discuss a few case studies where you can understand that how this conflict of interest may have arisen. The first case study is dealing with respect to the conflict of interest in pharmaceutical research. The scenario, what may be the scenario? A university researcher conducts a clinical trial which is being funded by a pharmaceutical company and also own shares in that very same company. So what may happen with respect to that particular research? Right, a particular research is being done by a university researcher where that particular research requires certain clinical test, and that clinical test is being done with respect to a pharmaceutical third party agency, that is a pharmaceutical company, and you own that interest, you own that shares or any kind of uh, control in that very company. Then the key issues may be there may be the potential bias in reporting the drug efficacy. Whatever will be the ultimate clinical outcome or the result of the clinical trial may not be given by that particular researcher because of the conflict of interest. Right? So this drug efficacy cases may have arisen in such situations. There, this point can have been raised. So this thing may have arisen, or IP rights over this drug novelty that can also be arisen. Right? What IP rights that particular drug novelty which has been done by that researcher. So this kind of conflict of interest may have arisen in those pharmaceutical research. What you can consider that what is the point for the discussion? Suppose if that particular researcher would not be having that shares in the same company, then what the result would have been done? Right? The result would have been completely different. The biasness has been reduced a lot in with respect to the reporting the drug efficacy and also with respect to the IP rights, right? So this may be the situations which can be avoided. So this is like the first case study. The second case study is also dealing with respect to conflict of interest in technology research. So a tech company that sponsors any professor's AI research with the professor holding consulting role in the same company. So what may happen? That mere clear-cut case of conflict of interest in those technology research. Fine. So key issues that influence on the publication and patenting decision, because that particular professor is holding the connection with respect to the same company. So if any research which is being done by that, the professor will not be having any transparency because of that particular financial assistance or financial help. So what may be the potential discussion in that situations? Like those particular research was not been required to be sponsored by that tech company. In that situations, the result would have been different. So this may be the situations where the conflict of interest has been arisen. Or the third case study that you can see or take is with respect to conflict of interest in IP licensing. A startup which is funded by the researcher at a university, they commercializes a new invention and the university claims joint ownership of the patent. So in that situations, what may happen? That the conflict of interest may have arisen between those particular academic objective and commercialization interest that may have been arising. And the complications in IP sharing agreements, there may be certain kind of complications with respect to IP sharing agreement, right? So this is the case studies where we can see that the in conflict of interest cases may have been arises or may arise in that situations that the conflict of interest or the research integrity will be hampered. Now, managing conflict of interest in research, institutional role. What is the institutional responsibility? So they can develop clear policies regarding conflict of interest. They like have the ethics policy, they have the research policy, they have the IPR policy. Like that, they can have the conflict of interest policy also, COI policy. Right? There are certain institutions which are having this conflict of interest policies. With respect to that, this is the responsibility of each and every institutions to avoid this conflict of interest. They can set up transparent processes for disclosing and addressing conflict of interest also. This is very clearly set up, is being done. The transparent process is there with respect to the disclosing their interest and also addressing if any kind of conflict of interest may have arisen. IPR focus. They can also form committees to review IPR conflicts in university industry collaborations. If there is any collaboration between university and industry related to the IPR, then they can form a committee to review all those IPR conflicts may have arisen, right? May not be directly the IPR research is being done. If there is any research where the IPR issues may have arisen, for that the committee have been formed by that particular institutes. They can also develop a code of conduct for IPR commercialization and research integrity for the commercial exploitation and this research integrity. They can also come with that. The institute or university can also come with this model code of conduct to develop that situations. So these are the certain conflict of interest where it can be managed in research by the institutes. Regulatory guidelines is also there. There are certain policies, there are certain guidelines which is with respect to this particular conflict of interest. The major guidelines that you can see, that the one is of WHO guidelines on this clinical trials conflict of interest. For the managing conflict of interest in clinical trial, the WHO guideline is there, and where it has been very clearly said that this informed consent is being disclosed, and there should not be any kind of conflicts or the vested interest. That should be transparent well in advance before the starting of the clinical trial. Each and everything is being mentioned. So this is the being given by that particular WHO also. One is also NIH conflicts, NIH policy, that is National Institutes of Health conflict of interest policy. So this is basically with respect to the public health. If there is any research which involves the public health, in that this NIH is also taking care with respect to that conflict of interest, and they are also saying that the transparency or like the information or the integrity should not be hampered. Well in advance all things can be mentioned. If there is any kind of, which is being said, that substantial financial interest, SFI, substantial financial interest. If there is substantial financial interest up to the amount of a certain amount they have fixed, that is of $5,000, more than $5,000, if there is any kind of financial interest is being given to any person, then that is being considered as substantial financial interest, and they are required to clearly disclose this very interest if they have with respect. This is the one of the NIH conflict of interest policies where this is being addressed. Universities, that I told you, that with respect to the various institutes, various universities, they can come with respect to these policies on all these conflict of interest in research and IP management, so that they can avoid. That the example that I have given you, that this NIH's requirement for researcher to disclose the financial interest that might affect their research. So if they have substantial financial interest, then they have to disclose it. This is one of the guidelines. Now, finally, in conclusion, what we can say, that the key takeaways, that the conflict of interest that can undermine both academic as well as the commercial research, and the integrity and the honesty and the quality can also be challenged with respect to any academic or any commercial research where the conflict of interest involved, transparent disclosure and institutional policies that are also very critical. So there should be very transparent disclosure and the institutional policies. Proper management of conflict of interest is crucial for maintaining trust, especially when IPR is involved, right? So finally, what we can say that balancing in when innovations, integrity, and intellectual property right, that is essentials in today's research landscape. From that point of view, if we are going forward with respect to all these innovations, integrity, and IPR and IP rights, we also have to take care with respect to that of the research conflict of interest. So this is all from my side. Now, if there is any questions or any doubt or any point you want to ask, now the floor is open. You can ask your questions. Thank you.
No, sir, there is no question. Uh,
All
Thank you so much.
okay. Okay. Thank you.
Thank you, sir, for the insightful session. We are thrilled to hear you today and gain knowledge on the topic. Uh, Now it's time to formal vote of thanks. I would like to extend my sincere thanks to Dr. Ashraf Khan sir for the insightful session on conflicts of interest in academic and commercial research. His experience has greatly deepened our understanding of the importance of intellectual property in academia. No one better than Sir could have guided us on this topic with the deep understanding and vast knowledge on the topic. So we are extremely grateful to you, sir, for taking the time out to join us and share your valuable wisdom and insights on the topic. Your presence has truly uh, elevated the session today. And also, thank you to all the attendees for your active participation. We look forward to applying these insight, insights in our work. Now we are ending today's session here. Thank you, everyone.
Thank you. Thank you all. Thank you, Dr. Uzma, and thank you, the Integral University and the HOD ma'am, that is Dr. Seema ma'am, and to also Dr. Tulika for giving me this opportunity to deliver this lecture. And I hope it would be very fruitful, and the coming days would also be very fruitful for this attending everything. Thank you. I think we can leave this.